No, that's just girls. I was like,
They passed the win law, which we expected that they would do, even though there's no rush and even though we won the primary election. And none of those people will be sitting around the table come January 1. They knew it's our intent to change the law. It's the will of the people to want to have a law that's more protective. So they circumvented that tonight by making sure that they pass the law now while they're lame ducks. Then to add kind of more of a smell to the rose, they decided to enter into an agreement with Invenergy to enter into a future agreement prohibiting a change in any win law by the town board. And if in fact a new town board comes in and decides to change the win law, they will enforce their rights under this letter of intent that our board so recklessly, and I'm using that word for a precise reason, entered into. It's absolutely outrageous. It's unconscionable. It should be criminal, but unfortunately it's not. The fact of the matter is the Article 10 siding board has to apply local law unless they can show that it's unreasonably burdensome. This board could have passed a protective win law, and the board would have had to have honored that law. Instead, they decided to go forward with the law that Invenergy wants. It's outrageous.
Oh yeah, everyone does have to sign in. There's a sign-in sheet in there, and it's numbered where 50 hits. Okay. So.
how you doing?
That's right.
No.
Excuse me, you're going to need to move instead of holding the door.
Oh, Trigger.
How you doing, Brownie?
I'm being kind to Miller, thank you.
Actually, I'll do the same thing since you did that. Ginger, make sure that other people
Ginger, get your hands off.
Get your hands off my wife. Get my hands off my wife. Then leave.
Please move.
Excuse me. Thank you.
Updated by the end of August.
Okay, that's it? Yep. Thank you, Judge. Any other officials have anything to report? Okay, we have 5 people that put in to speak tonight on the agenda. Other than that, we won't be accepting any more public comment tonight. So we'll start with Ginger. You're first. Huh? You got 3 minutes, Ginger.
Do you know how infuriating it is for the residents of Farmersville, the majority of whom do not support this project, and have begged this board for greater protections, to watch you roll back those protections from what is unacceptable to them before to even worse parameters? To watch what is widely believed to be an Invenergy hand-picked lawyer for the town, Mr. diMatteo, actively work against the residents and demean them, work against their wishes, which wishes have been conveyed to the board in numerous ways through the information session, the public hearing on the 2018 win law, the town survey, which you, Mr. Zink, were a part of asking for, the Article 10 public hearings, and last, but what both the county legislature and the IDA is calling a referendum of the people of freedom in Farmersville, which was the primary election, where the pro-wind agenda took a catastrophic blow. They continue to wonder, Rob, who it was that paid for all of your very nice, professional, numerous mailings to people. In fact, they're going to keep wondering because, in violation of the law, you haven't filed your financial disclosure report. What's more frustrating is the knowledge that not one of you, including Mr. diMatteo, really understands this project. The questions that you have asked in the last couple of sessions, I think, I'd highlight that. I don't think one of you has read the full application. I can tell that David hasn't. You've paid him a lot of money. Has the state reimbursed the town the thousands of dollars you've spent on his advice? He got the county referral wrong. He was wrong about the fact that the intervenor funds could be used for wind law development. He's wrong about the fact that 450-foot turbines are not in production anymore. You should be asking yourselves, what else is he wrong about? No one but Mr. Zink asked any meaningful questions when he read the new wind law to you line by line. This is all a crafted, and not so carefully, dog and pony show to make it look like you're giving serious thought to this law before you shove it down everyone's throats. When the fact of the matter is, you're doing this because Invenergy wants you to do it, and they promised you what you think is a lot of money to the town to sell out the health and the property rights of your citizens. You won't be sitting here when Ann Crotty and Shane Crotty come to you and come to this board and ask why they're getting 200 days of shadow flicker, or why Chris Weber is getting 174 days, or David Hughes is getting 114 days, and so on, because you have chosen not to regulate shadow flicker. And Invenergy's answer to the fact that they're over the 30-hour limit that the state would want to set is simply that they're going to buy blinds for everyone so we can sit in our houses on the sunniest days. So why haven't you protected us from that? Well, for those who vote for the law, I'll call you Judases, because that's what you are. Invenergy's proverbial 30 pieces of silver will be spent by this town on litigation in the months and years to come for your betrayal of these people. That's if you vote in the law tonight and this project happens. You know, at the end of the day, I don't think it's any secret that I and my husband are independently wealthy. In April of 2017, when we heard about this project, we could have skipped town, simply left our farm with a caretaker and bought a place in Alle-Cattville. But we stayed to fight, and we stayed to fight because there's a lot of people in this town that cannot afford to do that, and you have betrayed them.
I started the timer before you even walked up or started.
Of course you did.
No, I didn't. I'm not even running the timer. I'm not arguing.
10 seconds short.
Start his time now.
I'm timing them too.
I'm the president of Farmersville United, representing hundreds of residents. Our voice was clearly heard at the primary election, but you continue not to listen to the overwhelming majority of what the townspeople want. We asked for increased setbacks of 3,000 feet, which all of you have. Rob, you're the closest. You have 3,200 feet from you. George, you're next, 1.5 miles. Richard, 2.4 miles. Pam, 2.8 miles. We want 3,000 feet. Great for you guys. What's insane is you're considering a wind law that's worse than the one the county rejected. Now, over the last few months, you hired an engineer. You said the engineer was to protect the health and safety of the residents. Really? But you didn't let the residents ask questions. To make matters worse, when the residents tried to bring health concerns like shadow flicker, the town lawyer forgot his role as a consultant to the town and demanded that a resident be forcibly removed. Sure doesn't sound like you're looking out for the health and safety of the residents. The last meeting you were concerned about the roads being damaged by trucks. The engineer stated the town roads don't have sub-base material and it will be devastated by 10-wheeler dump trucks. Now, what's totally mind-blowing is that over these meetings, not once did any board member ever mention that Invenergy has made major changes to the project. Now we're going to have a concrete batch plant and a huge laydown yard in our town of Farmersville that will literally bring hundreds and hundreds every day of these dump trucks that will devastate our town. This is what you were concerned about. How did no one mention this at any of the meetings? Invenergy spends thousands of dollars sending staff and lawyers to these meetings. Not a peep. You better wake up. If you knew about this, shame on you. If you didn't, you better ask why. It gets worse. The concrete plant will at least draw 53,000 gallons of water a day. Invenergy states that this is the equivalent of 175 four-person homes. This will kill the farms around it. Rob, your family lives there. I can tell you, this is nothing like the gravel plant like Granat or Schwab's. I personally worked at concrete plants. The noise and dust is unbelievable. This is many levels worse. You don't take this lightly. This is industrialization of our rural, quiet town. They also added another turbine model, which has much larger turbine blades, which will increase the noise and shadow flicker, which will affect a lot more of the residents. So in closing, I will ask you that you will give all the residents the setbacks that you have and not place the industrial power plants 660 feet away from the property
You can
line.
leave if you don't want to go by the rules, okay?
I'm done.
I gave you 3 minutes.
Thank you, Rob. Thank you.
10
Jeannie,
seconds, 10
you're up.
seconds from me, so we have mine.
I'm going now. You have been told and given a stack of peer-reviewed articles proving that turbines cause infrasound and that infrasound is harmful to human health. You have been told that the pulsing, annoying, audible sounds of wind turbines causes chronic sleep deprivation, and that both of these things cause many health problems, most notably high blood pressure, which can lead to heart attack and stroke, which can kill you. You have been told that shadow flicker destroys concentration and can cause seizures. You have been told that industrial wind turbines are not green. The low estimate of 20,000 acres to be decimated is larger than Grand Island, which is only about 18,000 acres. The rare earth minerals required for the turbine magnets for an only 2 megawatt turbine is 930 pounds, or almost half a ton. The mining of a ton of rare earth minerals produces about a ton of radioactive waste, according to the Bulletin of Atomic Sciences. There was more radioactive waste from turbines from nuke plants in a year than there were from, they made more radioactive waste than the nuke plants in a year in this country. Very not green. And the 25,000 diesel trucks coming in and out, the environmentally hazardous concrete production that will probably ruin our water supply now, and the blades that must be frequently replaced and added to landfills, and the totally disrupted ecology of the area and animal life, and the green argument goes out the window. You have said that other towns with turbines have no complaints, but you couldn't get through to Orangeville, which is Student Energy, or Sheldon, where they put toxic slag under the roads there. The electricity goes to 13 other states while our area is completely destroyed. Keen Stim's company has turbines that are 1/12 the size and 50% more efficient, according to WBFO's Chris Cava. These GE turbines are totally obsolete. So what are we even doing here? I figure 85% of big government is blackmailed, threatened, or bribed, but I didn't think it would happen here. I guess I thought people in small towns were more moral. What a joke. There was a survey and an election. The board knows that people have rejected this law as it is, and as punishment to us, have proposed even closer setbacks. Really childish. You took a vow to protect the health, safety, and welfare of this town. I think we can add lying to your list of sins. You should be ashamed of yourselves for putting your own greed above us. If you stay, you'll have to walk among those you betrayed. We have shown more due diligence than those who were paid to. Can Invenergy say that chronic sleep deprivation and infrasound do not harm human health? Can you tell me that my body and my home will not be of the resonant frequency to cause my walls to reverberate or cause me heart palpitations? If you can't promise these things, then what the frig are we doing here? I don't think that the newly appointed Mr. Duncan has been privy to all of this information for all the good it would do, and a couple of you may actually be selling out your own mothers. What comes around goes around. No good will come to you if you do this. There will be ill-gotten gains. You will have bad karma with a capital K, especially if it results in deaths. That's how serious it is. You could kill people.
Bob? You're helpful.
I don't know, previous people have pretty much said what I could have said. I've got a thing here that says, I wonder if you guys have looked at the total megawatt hours expected from each turbine and the entire wind farm based on certified third-party determination. The average winds in the Farmersville area. The kilowatt hour cost of the power produced based on the above power output looks to be about $2.40 a kilowatt hour. Figure it out. The kilowatt hour cost, no government subsidies, grants, or tax abatements. If they were removed, what would you have? In the case of the developer's bankruptcy or abandonment of the project, how would the turbines be removed and who would pay? A lot of you guys have a big stake in this, personally, and this stinks. And I could ask each one of you individually how you or your family are going to benefit, but I don't want to really embarrass you, although you should be. You should be embarrassed at this. This is ridiculous. You were elected to protect the people of this town, and you are not doing it. And I don't see how you can feel in good conscience to get away with it. I think the lawsuits will fly very soon, and you'll probably all be involved. And I feel sorry for all of you. I feel sorry for you morally. I feel sorry for you in a lot of ways.
They've got
I'm
no
done.
models.
Kathy Kellogg, 3 minutes as well.
I don't have anything written down, but I am here to tell you that I'm very disappointed in all of you. The atmosphere in this room is not acceptable. You have people trying to participate in their local government every month, and they can't even come in the room. There's lots of room in here. I'm disappointed that less than a month from the deadline for us to submit comments, there's a whole new batch of information for us to review. You people haven't told us about it. We had to just hear about it. Shame. Shame on you. Shame on you. You're gonna have to live with yourselves later. All this stuff is gonna replay in your head. We've seen 2 lawyers, 2 engineers. This is expensive, it's complicated. We expect you to know the technical stuff that is in that box. You're supposed to represent us.
That'd be up for public comment. Old business. And helping first.
Yeah. Well, no, let's go through this and then it's under any other old business.
Okay, water machine.
That's turbine 101.
That's,
I'm sorry, Mr. Chairman.
it's still on back order, but we have one out in the highway department at the top load bottle Barry told me about, so I'm gonna check that one out. And if we can use that, we might as well use that.
Just get the bottles.
Just get the, you know,
I have no problem with
okay, pretty good.
that. Pretty simple.
Because we don't use it anymore, so.
Okay, solar, we need a date and time, I believe, Dave, for the solar public hearing.
Have we referred that to the county planning board? I thought we did last month. We have not. I'm sorry? Okay, so we might as well refer it, wait for their recommendations. Okay. Because we did go through last time, the part 1 of the seeker. I thought we referred it at that time, but I'll take it upon myself to send that solar law.
Okay, very good.
So you're referring to the date.
I'll go to county assessment first. Okay. Okay, we're up to the wind.
You want to talk about the Cattaraugus County Hazard Mitigation Plan update? Or are you going to wait until that later?
Yeah, that's in new business, I think.
Okay. Well, senior exemption was too. I jumped on
Yeah,
you.
right, well, you're talking about the assessing,
Okay.
so. Richard, we're gonna need you to,
Yes, I want to recuse myself to,
okay,
since you're
appreciate it.
talking about the wind law. We'll see you later.
Speak up, we can't hear anything.
I said I'm gonna recuse myself.
Okay. Go out and enjoy the fresh air. You can leave that there if you want. Should've.
Are we going to come back in and do things, or is he done?
Yes, he's coming back in.
We'll watch your stuff for you.
Take care. Yeah, I'm sorry.
Where you go out the back door?
This is the,
That's a letter from me.
Okay, go ahead.
Since the town began a review of its local wind energy conversion facilities last year, the town board members have sought counsel, and the town's attorneys carefully considered their participation in this process. The board members have been advised of their options after extensive legal research and based upon careful review of the facts and the circumstances regarding this matter. One board member has elected not to participate, even though my office has concluded that there is no conflict. Second board member, who has no conflict, decided to participate. A third board member, who likewise has no conflict, has also decided to participate. While I, as town council, have explained this reasoning during prior town board meetings, We thought it would be helpful to further reiterate it to the public and to provide everyone with copies of this statement, including the following legal analysis upon which it is based. The statutes applicable to conflicts of interest are contained in Article 18 of the General Municipal Law, attached hereto as Exhibit 1, and the town also has its own code of ethics attached hereto as Exhibit 2. In general, the General Municipal Law prohibits contracts between public officials and their municipality and provides specific prohibitions with respect to a public official's conduct. Section 801 prohibits a municipal officer or employee from having an interest in any contract with the municipality if the officer or employee has the power or duty to negotiate, prepare, or authorize and approve it. Here, the WEX local law that the town board is considering is not a contract with anyone. It's a local law of general applicability. Next is Section 805 of the General Municipal Law. It applies to agreements for services rendered to a town, and it specifically prohibits municipal officials from soliciting and receiving gifts, disclosing confidential information, or receiving compensation in relation to matters before the municipal board. For example, an architect who is also a town board member can also represent the applicant before the town planning board. That would be an impermissible conflict of interest under Section 805. Again, nothing of this sort is an issue here. No town board member has been hired to provide services related to the matter before the town board. The town board is considering a local law of general applicability, not a specific zoning application or contract. Under Section 1809(1) of the General Municipal Law requires that all zoning applications to contain a disclosure statement informing the municipality if the state, county, or municipal official has an interest in the applicant. Here, again, there is no zoning application before the board with respect to a wind energy project. The wind energy facility applications for projects of greater than 26 megawatts in size are made to the New York State Siting Board in Albany and is part of the Article 10 process. The town board is considering a local law of general applicability. Under Article 10, the town board does not decide whether a particular wind project is approved, nor is it allowed to conduct an environmental review under seeker for a particular wind project. Again, the state legislature, in all of its wisdom, decided that towns and local municipalities could no longer decide these issues. Anytime a town board member in a town votes on a land use zoning law, there is a good chance that he or she is voting on a local law that could impact their property, but it does not mean they can't vote on it. Otherwise, no one could ever vote. The Court of Appeals has made this abundantly clear. Notably, the General Municipal Law refers to a dependent child and parent with respect to conflicts of interest as opposed to adult children and parents. Farmersville also has its own code of ethics. It prohibits town officials from, among other things, taking any action, which includes voting, that he or she knows or has reason to believe will result in a material or financial benefit for a family member or dependent. The definition of family member includes in-laws, adult children, and parents. Applying these legal requirements and principles to the situation here, I provided the following conclusions to the board and reiterate them here and now. Board member Richard Westfall signed a lease with Alle-Catt Wind Energy. We do not believe this to be a conflict because the town board is voting on a land use law of general applicability, not a particular application, project, or contract. Although he had no legal obligation to do so, he decided to recuse himself from deliberating or voting on the WEX local law because he himself has a lease. Supervisor Karcher's in-laws, not the supervisor himself, contrary to some incorrect claims, signed a lease with Alle-Catt Wind Energy. He does not have a legal conflict of interest with respect to deliberating or voting on a wind energy conversion system law, local law, because it is a land use zoning law of general applicability. Again, it is not a permit, application, or a contract from any particular developer or company. Indeed, the town does not grant the approvals for the particular wind energy project. The New York State Siting Board does through the Article 10 process. Whether some other state board at a future time will grant a certain permit or approvals for a specific project based upon specific evidence and facts pertaining to that project is entirely speculative. For the same reasons, however, Supervisor Karcher has decided not to participate in any board deliberations or voting regarding a separate matter, a potential host community agreement with Alle-Catt Wind Energy, or a road use agreement. Unlike the general local law, a host community agreement and a road use agreement is an actual contract with particular company. Under the town's code of ethics, Mr. Karcher is prohibited from voting on any contract that would confer a material benefit to his family, the definition of which includes his parents-in-law. Because of his in-laws live in the town, he chose to recuse himself from the host community agreement and the road use agreement. Although the host community agreement does not confer any specific benefit on Mr. Karcher's in-laws, he did not want to give the appearance of a conflict. Board member Richard Zink has no legal reason to recuse himself from any of these votes. Although his parents have a lease with Alle-Catt Wind Energy, they own land and live in an entirely different town. There is nothing before him that affects his parents or their town. This land use law is only applicable to the town of Farmersville. For those who claim that none of these three board members is permitted to deliberate or vote on this WIC's local law, please also consider this. It would mean that the current board could never vote on or change its wind energy conversion law because the majority of the board, 3 out of 5, would have purported conflict. And even if 2 members were accused of having a purported conflict with respect to the local law, the board still could not vote on it, as it takes 4 votes to override the recommendation of the county planning board. I do not believe the law regarding conflicts of interest is intended to prohibit an entire board from taking action, particularly on land use zoning laws of general applicability. To summarize, after careful research and review, I previously concluded and reiterate here that neither Mr. Westfall nor Mr. Karcher are legally prohibited from reviewing and voting on the land use zoning law of general applicability. They have, however, decided based upon the town code of ethics that they will recuse themselves from voting on the host community agreement, the road use agreement, which is a contract. The Alle-Catt Wind Energy, with Alle-Catt Wind Energy, because either they or their in-laws live in the town and have a lease with Alle-Catt Wind Energy. Mr. Zink is not prohibited from voting on either issue because his parents do not live in the town and nothing before him affects his parents or their town. Because of some individuals and groups have already threatened legal action against the town regarding these votes, I've advised the town board not to further discuss the matter beyond what has been provided in this statement. I thank you. If you can make sure that becomes part of the record.
Yep. Thank you, Dave.
Good. Steve?
I think you've all got a copy of local, would-be local non, are we at 1 still? It seems like we've talked about so much. Are we still at 1? No problem. Again, just taking you through where we've been. This is a regular board meeting that's been called for some time, that the town board of the town of Farmersville is considering a local law entitled Wind Energy Facility Law of the town of Farmersville, New York, which would repeal and replace local law number 1 of 2009, number 1 of 2008, and number 1 of 2007. On October 18th, 2018, this board held a public hearing on the local law, referred it to the county planning board. On December 3rd, 2018, the town board, as lead agency pursuant to the State Environmental Quality Review, reviewed the full EAF and took a hard look at the potential environmental impact and issued a negative declaration. Basically, at this point, the law is properly before you, and you could consider adopting it if you so choose.
We need a motion if you want to go into a roll call vote.
I
make a motion.
Motion by George, second.
I'll second it.
Second by Pam, all in favor?
Aye.
Aye.
Carried.
Hold on, before this starts, everyone stay in your seats, okay? Go ahead.
Mrs. Tilton? Yes.
Mr. Duncan? Yes. Mr. Zink?
Yes.
Mr. Karcher?
Yes.
So the next steps we need to do is notify the county planning board of this resolution and file it with the Secretary of State.
Okay. Thank you.
Let the lawsuits begin.
I already got the email.
That you do, right?
Oh, Jeannie, I'm sorry.
You can build your road,
George didn't
right?
get his letter, so I can give it to him.
Dave,
Yep,
do you do the
You
county
can go
planning
over if you
board?
want.
I will do it.
Okay, cool.
Actually, I think I have a letter, Rob, just responding to the county
You don't have
planning,
your email, George.
responding to the county planning board.
Can you sign it?
Yes, if you could, it's on the right-hand side. And I'll take care of getting that filed with them.
Yes, sir.
Thank you.
Anything else on that?
I do. We have a letter of intent from Invenergy.
Gone.
And Rob, if you could excuse us, you could leave.
Oh, I'd be happy
Good.
to go. Where's my phone? My pocket.
It's all bad.
Again, the letter of intent, I can read it to you. Regarding potentially a host community agreement and a road agreement. I know we've seen iterations of these, but this is a letter of intent made by Alle-Catt Wind Energy, a limited liability company formed and existing under the laws of the state of New York and the town of Farmersville, a municipal corporation organized under the laws of the state of New York. Whereas the company is applying to the New York State Board of Electric Generating, Siting, and the Environment for Certificate of Environmental Compatibility and Public Need under Article 10 certificate for a wind energy electric generating facility the company is developing on various parcels and land located in the town and neighboring towns. The company plans to request Cattaraugus County Industrial Development Agency to provide financial assistance for the development and the operation of the project. Such assistance would include, among other things, the IDA's lease or sublease from the company of the company's interest in the land and the improvements comprising the project, with a lease back of the project from the IDA to the company, and a payment in lieu of taxes between the IDA and the company, pursuant to which the company will make an annual payment that the parties anticipate will be based on a rate of not more than $5,000 per megawatt. And whereas the company's pilot payments are to be allocated among the town and the school district and the county in which the project components are located, using percentages to be set forth in the pilot agreement. Whereas the project will be subject to an ad valorem fire department and other special district taxes based upon a rate calculated using a budget approved by the town. Whereas according to the current special district rates and expected assessments of the wind turbines at the special district taxes divided by the number of megawatts of wind capacity to be installed is expected to be less than $600 per megawatt per district. Whereas the company and the town intend to enter into a road agreement and a host community agreement. Now, therefore, the parties hereby affirm their intention to negotiate in good faith and to execute that by September 16th, 2019, a host community agreement and a road agreement containing the following: host community payments. The company will pay the town annual host payments for 20 years. The first payment will be made 30 days after the first anniversary date of commercial operations defined by the project begins selling electricity generated by substantially all the wind turbines included in the project to a third party. Subsequent host payments will be made every 30 days, within 30 days of completion of each 12-month period. Terms of the payment are: the host community payment shall be calculated as a nameplate capacity of $6,450 per megawatt. For every dollar that the pilot rate is less than $5,000, the town rate will be increased by $1 per megawatt. For every dollar that the pilot rate is over $5,000 per megawatt, the town rate will be decreased by $1. For every dollar that the special district tax is assessed on the project in the town divided by the number of megawatts installed exceeds the maximum district rate, the town rate will be decreased by $1. By way of example, the project were to install 85.2 megawatt nameplate capacity in the town. The IDA entered into a pilot agreement with the pilot rate of $5,000 a megawatt. The town's percentage of the pilot was 28%. Then the town payments would be as follows: $549,540 host community fee, $119,280 in pilot payments, pilot rate of 28%, 85.2. Total payment by the town to the town of $668,820 per year. The parties will enter into a road agreement with the following provisions. The town will permit the company to install buried cables under the town roads and to modify intersection and roads to accommodate project deliveries. The company will repair road damage caused by the project construction, and such repairs performed per specification the town typically uses in repair and resurfacing. During construction, the company will post a bond equivalency of $500,000 for the performance of the road repairs. Professional costs. During the term of the LOI, the company will reimburse the town for reasonable legal fees it incurs to defend an Article 78 proceeding and any other lawsuits related to the project. The host community agreement will include for the company to reimburse the town for reasonable engineering and legal costs incurred by the town and are not covered by Article 10 funds that are necessary to implement the host community agreement and road agreement, up to a maximum of $50,000 for any year in which the project construction occurs and $10,000 for any year after the project is operating and not in construction. Conditions. The company reserves its right not to enter a formal agreement on the terms of the LOI in the event the town modifies its regulations in a way that could materially interfere with the ability of the company to design and install and operate the project. By proper action of the town board, the deputy supervisor is authorized to sign this letter of understanding.
Could you read that last section again, David?
The last one, the authorization?
It starts with the LOI.
Okay. By proper action of the town board, the deputy town supervisor is authorized to execute this LOI on behalf of the town.
It was the section before that.
Conditions?
Correct.
The company reserves its right to enter a formal agreement on the terms of the LOI in the event the town modifies its regulations in a way that could materially interfere with the ability of the company to design, install, and operate the project.
Very clever, very clever.
That's what you're doing.
Lovely.
So I guess we're looking for, basically this would be a resolution of this board to enter into this letter of intent and allow Richard on behalf, as a deputy supervisor, to sign this letter of understanding, or letter of intent.
So we need to make a motion?
Yep.
I motion that we move forward.
I'll second it.
Okay.
Poll the board.
Letter of intent. No, letter of intent, what's it, formal?
It's here's the resolution. It's, the town board finds that the letter of intent attached here to as Exhibit A sets forth the certain terms that provide for a mechanism to carry out mitigation conditions the town would have required of the applicant had Article 10 not applied, and additional economic benefits which are in the town's best interest. Attached to the letter of intent between the applicant and the town is hereby approved, and the deputy supervisor is authorized and directed to execute the agreement on behalf of the town.
So George made the motion, Richard seconded. Just want to make sure I got everything right. Mrs. Tilton?
Yes.
Mr. Duncan?
Yes.
Mr. Zink?
Yes.
Circumventing the will of the voters. That is incredible, incredible work.
I think you get Robin. Yeah.
It's going to be short-lived.
You enjoy your troubles in Florida.
How many of you are gonna move?
I'll live on the page.
Got no models.
Mr. Westfall, too?
Yeah, absolutely. That number was $668,820 a year. Yeah, $6,450 per megawatt.
Good job, buddy. I could have used you back when I was in business. Still be in business.
I don't know if you have anything else for me, do you?
What's the mitigation?
The hazard mitigation plan?
Yeah. Do you have any other old business? You wanna wait on that?
No, so
6
6 PM. That'll be Pam, George, Richard, and Barry.
Okay. That's all I've got. Thank you.
Okay, yep, good night. Any other new business?
Make sure you take all your energy files with you.
Motion to pay bills?
I'll make a motion to pay bills.
Motion by Pam, second.
I'll second it.
Second by George, all in favor?
Aye.
Carried. Person for adjournment.
I'll make a motion for adjournment.
Motion by Pam.
Second.
Second by Dick. All in favor? Carried.
Always want to do that one. I voted yes because I believe it'll be to the interest of the town, that it will be not only financially, but we have a God-given resource called wind, and we're using that to do our part in providing electricity, green energy to others. Thank you.
How they voted and why.
no comment, please. I have no additional comment.
Meeting's over. No comment.
Do good.
Yep, Judas.
680,000. 660, 69, 669. Does that approach what you're saying?
Which is decent price for each adjustment.